today. My name is Jeremy Weber, and I'm the Dean of the Faculty of Law. And it's appropriate always, and especially on this occasion, to acknowledge that we're meeting on the traditional lands of the Songhees, Esquimalt, and WSÁNEĆ peoples. I'm always impressed with a feeling of gratitude and responsibility when I make that acknowledgement, and especially so today. I'm very pleased on behalf of the faculty to welcome you all here to this very fine panel on a crucial and timely subject. Professor Deborah Curran will introduce the panelists and thank them properly, but just let me say a few thank yous just to begin. This event is jointly organized between the Faculty of Law and the POLIS Project on Ecological Governance here at UVic and the Center for Global Studies at UVic. And I'd like, therefore, to thank Raluca Levka and Laura Brandes for their work in making this happen. And from the Faculty of Law, I'd like to say a very special thank you to Margaret Suderman for her work at organizing this, and to Professor Deborah Curran, whose idea this initially was, and who I think fingered the panelists as well for this great discussion and this great panel. So thank you to the panelists, thank you all, and welcome. Deborah.
Thank you, Jeremy, and hello, everyone. This is a fantastic turnout, and we have additionally over 100 people by webcast from across Canada who are equally interested in hearing our discussion today. So just by way of, I guess, logistics, everyone's going to have to speak into a microphone. Unfortunately, it will stilt our theatrical or our wandering interests as we do this. So if you do ask a question afterwards, please do wait for the microphone to come to you, and Margaret and I will be kind of doing a tag team to try and get all of the questions in, or as many as possible before 6 o'clock, and we will also be answering questions from people online, so through Twitter and through email as well. The other thing is, too, if you're uninterested in having any of your image, even the back of your head, on the recording, because we are recording it to play again here in the Faculty of Law. There are a number of students either in class or who are at the Aboriginal Awareness Camp who are unable to be here, and so we wanted to keep a record so they could benefit from this as well. Please let the technicians know. I'm pleased to have the role of introducing our distinguished panelists, who will be giving us their thoughts about an experience with the recent Supreme Court of Canada decision, as you know, the Tsilhqot'in Nation versus British Columbia that we've all come to hear about, that was handed down by the Supreme Court of Canada in June of this year. Most of you will know, or at least the way in which the decision is discussed sort of popularly, is that this is the first time that Aboriginal title has been confirmed by a Canadian court, I would say a colonial court. But more than a legal precedent or a statement of rights by our Supreme Court of Canada, or control over 1,700 square kilometers of land, this really is a decision about the experience of an Indigenous community who have been interacting with their landscape for thousands of years. We learn about their expression of governance, stewardship, citizenship, and commitment to the landscape and to their culture. And even if you do read the 40-odd page Supreme Court of Canada decision and don't come away with a feeling or a sense of that, I commend to you the 600-plus page decision from the BC Supreme Court and Justice Vickers, who very carefully goes through the evidence that's placed forward, and it's really not just evidence, it's statements by the community about how it is that they come to be in that landscape and in that traditional territory. So we are privileged to have with us three lawyers and scholars who have been involved in or keenly watching the Tsilhqot'in Nation case throughout all levels of court, and will be providing us with their thoughts today. And I'm just going to introduce all three of them, and then we can have a substantive discussion. So immediately to my right is Jay Nelson. Jay is a UVic alumnus from 2000 And he received the Law Society Gold Medal and then went on to clerk for Chief Justice Beverly McLaughlin, who I also believe had a hand in writing the decision in June. After that, he joined Woodward Company and became immediately engaged in the Tsilhqot'in, or with the Tsilhqot'in Band and the Tsilhqot'in Nation in the case as it started at the BC Supreme Court level. There's lots else I could say about Jay, but it's safe to say he's been busy since then, not just with this case, but also in assisting the Tsilhqot'in with opposing the Prosperity Mine in their territory as well, or also known in the area as Fish Lake. Next to Jay is Krista Robertson. Krista is an associate with James Friedman Kyle here in Victoria and has worked exclusively for First Nations and Aboriginal organizations since graduating here from UVic in 2002. She represents First Nations and tribal councils in advancing Aboriginal title and rights, resource use, consultation and accommodation and special claims, as well as deals with band governance and administrative matters. And finally, next to Krista is John Burrows. John is Anishinaabe Ojibwe and a member of the Chippewa of the Nawash First Nation in Ontario. He is also here in the law school, the Canada Research Chair in Indigenous Law. He has held a wide variety of academic positions across North America, through which he has written widely on Aboriginal and Indigenous law and legal traditions. John is a fellow of the Trudeau Foundation and of the Academy of Arts, Humanities, and Sciences in Canada. And in 2012, he was a recipient of the Indigenous Peoples Council from the Indigenous Bar Association for honor and integrity in service to Indigenous communities. So without further ado, I just have one more thing to say that I can say about all three of them. You won't meet a nicer group of people to hang out with, the three of them, but even better, you will never meet a nicer group of lawyers to interact with. So without that, I turn it over to you three. Thank you.
Good afternoon, everybody. My name is Jay Nelson, as Deborah noted. I'm the General Counsel to the Tsilhqot'in Nation, and I was part of the legal team at the Supreme Court of Canada. And I wanted to start by acknowledging the other members of that legal team, David Rosenberg and Jack Woodward, and all of the lawyers at Woodward Company that for the past 15 years poured a lot of blood, sweat, and tears into the case, Krista included at times. So I wanted to acknowledge all of them. And of course, I wanted to acknowledge the territory of the Coast Salish and Strait Salish people that were gathered on today. And I wanted to say it's an honor to be part of this event, and particularly to be on a panel with such esteemed presenters as I'm here with. It's actually a bit intimidating. But fortunately, they're doing the intellectual heavy lifting, I think, today, and I get the job of giving you the background to the case and a bit of the history. And I've tried to do it. I hope I can do it in a way that's not too lawyery. And I've tried to include a number of pictures from the claim area, in and around the claim area, in the journey to the Supreme Court of Canada, in case I am a bit too lawyery. Hopefully keep your attention for a little while. Let's see if this works. Great, so to start, just to situate ourselves, the claim area that we're talking about in this court case, it's outlined in yellow on this slide. It's in the central interior of BC, in an area that's not coincidentally known as the Tsilhqot'in region of BC. And it happens to fall within the traditional territory of the Tsilhqot'in and the Tsilhqot'in people. This picture here is of the plaintiff who represented the Tsilhqot'in and the Tsilhqot'in Nation in the court case, Chief Roger William. And just for your background, Tsilhqot'in is one of 6 Tsilhqot'in communities. And each of the Tsilhqot'in communities it was divided into an independent Indian Act band. But historically and to this day, they've always identified first and foremost as Tsilhqot'in people, and they identify as a Tsilhqot'in nation despite the divisions of the Indian Act. And Tsilhqot'in is the most remote of the Tsilhqot'in communities. It's actually quite remote. I believe it was until the 1970s that a road was built into the territory, and until then, the usual form of transportation was by wagon road to the nearest city, Williams Lake, which could be up to a 2-week return journey. And wasn't until, I believe, the early 2000s a phone system went in. It's still off the grid in terms of hydro. Quite remote relatively, and perhaps partly as a result of that, it has a very strong traditional culture. The language is still very strong in Tsilhqot'in. A lot of the elders speak only Tsilhqot'in, and people my age or older were often raised in Tsilhqot'in and speak it as fluently as English. So it's a quite exceptional place. And the litigation itself was provoked by planned forestry by the province. Provoked is the word the trial judge would ultimately use. And essentially there were plans in the early 80s and 90s for extensive clear-cut logging through the caretaker area of the Tsilhqot'in. This is a bit hard to read. It's a satellite map, and I'll just try and explain it to you a little bit. You'll see there's kind of a green triangle nearer the center. It's between the confluence of two rivers, the Tsilhqot'in and the Tsilhqot'in River. Below it, you'll see the blue. That's not water, that's high altitude mountain. And then all around it, you'll see beige patches. Those are clear cuts that are captured on the satellite imagery. So the claim area is essentially the intact portion that you see there, and the clear cuts come right up to the borders of the claim area. And the plan from the province was to authorize logging throughout that remaining area. And it's one of the last intact regions in Tsilhqot'in territory. So although the case is framed in terms of rights and title, at core it's really a story about cultural survival and the fight for cultural survival, really under immediate and direct threat. The Tsilhqot'in, each of the communities has a caretaker area where they hold the primary responsibility for caring for that area. This is Tsilhqot'in's backyard, their caretaker area. It's one that the trial judge would confirm they have a sacred duty to protect under their own legal system and their own worldview. So, the plans to authorize forestry in the region culminated in a historic blockade at Henry's Crossing in 1992 to prevent forestry from proceeding. And ultimately it went to trial. There's a long story there, but we'll cut to the chase. And it was a monster of a trial. The stats are up on the board there for you, but it was 339 trial days over 5 years. At the heart of it were 29 Tsilhqot'in witnesses who, for the most part, testified in Tsilhqot'in. Most of them spoke only Tsilhqot'in. And as well as numerous experts and just an enormous documentary record. And that was everybody's life for several years. The decision was rendered in November of 2007 at trial. And it was a success on the Aboriginal rights side, and it's a side that tends to get underappreciated because it's been eclipsed a bit by Aboriginal title. But the trial judge found that the Tsilhqot'in people have Aboriginal rights to hunt and trap throughout that entire claim area. And that included the right to capture and use wild horses, which is a practice that goes back traditionally before contact, and you'll see some depicted there. And that they had an Aboriginal right to trade in skins and pelts to obtain a moderate livelihood. So those were the rights that were found. I should also say the court confirmed that those rights vested in the nation, in the Tsilhqot'in people generally, and not in the specific bands, and confirmed the existence of a Tsilhqot'in Nation, which is something that British Columbia argued didn't exist at trial and actually on appeal as well. They argued there was no such entity as a Tsilhqot'in Nation. There was only these isolated bands. It was something the trial court rejected. And the court went on to find that the planned forestry was an unjustifiable infringement of those Tsilhqot'in Aboriginal rights. And essentially it was unconstitutional and unlawful. And he struck down the permits on that basis. And the reasoning is essentially because in all of this planning for forestry, the province hadn't planned for the continued ability of the Tsilhqot'in people to continue hunting and trapping. It didn't plan for the sustainability of their culture. To the point that, as the court noted, British Columbia didn't have an inventory of what wildlife existed in the claim area. They certainly didn't know what the Tsilhqot'in required for the exercise of their rights. And there was no plan in place for how this forestry and the exercise of these rights can continue into the future. And the court said that those rights have to have some meaning. They have to exist in perpetuity, and the planning has to recognize that from the outset. He found that the model we have of forestry in British Columbia is really driven by economics, and it doesn't have the flexibility under the existing legislation to accommodate different approaches to forestry, such as ecosystem-based forestry that the Tsilhqot'in had been proposing as an alternative to clear-cut harvesting. It was rejected. And I think this is important in terms of natural resource development in BC. The trial judge says that there's a need in British Columbia to develop a new model of sustainability in the claim area, and referring not just to the sustainability of the forestry resources, but to cultural sustainability, a model that really takes seriously the ability of a First Nation to carry out its culture in perpetuity. The Tsilhqot'in also claimed Aboriginal title at trial. And just so we're on the same page, Aboriginal rights give a right to engage in particular activities, hunting, trapping, fishing. But so far they haven't been seen as conferring any kind of ownership to the resources or to the land. Aboriginal title, as we'll see, is far closer to an ownership right. And so the Tsilhqot'in claimed ownership over the claim area by way of Aboriginal title. And at trial, the trial judge actually found that on the evidence, the Tsilhqot'in had proven title to about 40% of the claim area. And you'll see it depicted on this map as the darker red swath through the center and up the Chilko River corridor there. And he found that Aboriginal title was proven on the facts of the case to that area. But I should make this point as well. This is an important point. He found that Aboriginal title was established not just to areas where the Tsilhqot'in people had village sites, which were essentially winter pit house settlements, but also to what he called cultivated fields, which were the slopes of the valleys and mountains where the Tsilhqot'in people, that they actively managed for root vegetables, mountain potatoes, berries, medicines. He found that those were also regularly used sufficiently to establish title to the land. And he went more broadly to say that title was made out to the regular hunting, trapping, fishing grounds. So he found there that basically what we called in short term, the breadbasket lands, the lands that the community went to year after year, season after season, for generations. These are the lands they went to support their culture and support their communities and their economy. And he found that those lands were sufficiently regularly used to establish Aboriginal title. But at the end of the day, he stopped short of declaring Aboriginal title, a declaration that would give his findings legal force. And it's a complicated technical issue that frankly doesn't entirely make sense to me to this day, but if I had to summarize it briefly, the rationale was the Tsilhqot'in people had claimed title to two large areas that made up the claim area, known as the Brittany Triangle or Tsilhqot'in, and their trapline territory. But in their pleadings, hadn't specifically asked for smaller areas if title was found to that. And since the trial judge found that couldn't find title to the whole area, and only found it to this 40%, he said he was precluded, he was barred by the pleadings from declaring title to a smaller area. So I don't know if that makes sense to you, but that was the finding, and it left us in something of a gray area in terms of finding on the evidence of Aboriginal title, but stopping short of giving it legal force. So nobody was happy with that decision, and we ended up eventually in the BC Court of Appeal. Just very quickly, British Columbia appealed all the findings of Aboriginal rights, and the Court of Appeal dismissed BC's appeal and upheld all of the findings of Aboriginal rights throughout the entire claim area, including the right to capture and use wild horses and the trading rights as well. And the Court of Appeal went on to also affirm the trial judge's finding of unjustified infringement of those rights. The Court of Appeal also found that the authorized logging was unlawful, unconstitutional, just from its impact on the rights, let alone title. And as a result of the Court of Appeal decision, forestry couldn't proceed in the claim area. And actually, those findings on rights were never appealed to the Supreme Court of Canada. So those are final and conclusive. The hunting, trapping, trading rights are final, conclusive, and the finding that forestry can't happen without a new model of sustainability is also the law, and wasn't appealed. So important findings there. But overshadowed somewhat by where the Court of Appeal went on Aboriginal title. And The plaintiff on the appeal sought a declaration of Aboriginal title that would give legal force to what the trial judge had found. And the Court of Appeal agreed with the plaintiff that that technical pleadings issue shouldn't have been a bar to the trial judge issuing a declaration. But it disagreed with the trial judge on the law. And what the Court of Appeal said was you can't have Aboriginal title to these broad areas, hunting grounds, trapping grounds, gathering areas. Aboriginal title is a matter of law, no matter what the facts of any particular case. As a matter of law, can only exist to very specific sites that were intensively used. So village sites and fenced areas are the obvious examples. They gave another couple examples. They said you can't have Aboriginal title to a hunting ground, but if there was a salt lick that you went back to every year and you intensively used it, you might have Aboriginal title to that salt lick. Or you might have it, literally they said, you might have it to a particular rock that you stood on to net salmon. That's how narrowly they defined Aboriginal title. This was a view that this was the view of both governments, BC and Canada, and it had been rejected by the trial judge as a postage stamp view of Aboriginal title that he described as impoverished. So, and I just want to pause here. There's a lot of problems, in my opinion, others might disagree, with the Court of Appeal decision on this point, but I just wanted to stress for First Nations, for the Tsilhqot'in and other First Nations, what an affront or how denigrating it was to their culture to be told that only intensive use of land gives rise to a recognizable title. And because from contact on, the different ways that Aboriginal people use the land and govern the land has been used as a justification for dispossessing them of those lands. They've never used it in a way that legitimately gave rise to legal rights. And so to have a court in 2012, Court of Appeal, tell them that the only activities that give rise to a protectable, recognizable title are basically Eurocentric, very intensive use of the land, and their traditional ways of using the land aren't entitled to protection in the same way, or to a lesser degree of protection, was really taken as an insult and an affront. And that's why when people talk about the Supreme Court of Canada's decision being a recognition of Aboriginal cultures, it's in some part, I think, driven by that. So that was the issue that went before the Supreme Court of Canada last November. And as I mentioned, Aboriginal title was the only issue that went before the Supreme Court of Canada. And really the question was, is Aboriginal title restricted to those small spots? How do you prove Aboriginal title? And what does it mean for everybody on the ground once you have it? So as you know, the Supreme Court of Canada in June of this year unanimously declared Aboriginal title to the title area where it was found by the trial judge. And this is, as Deb noted, the first time Aboriginal title's been declared in Canadian history. So quite a historic event. And in coming to that conclusion, the Supreme Court rejected the postage stamp view of Aboriginal title, and it really swept aside the province's last justification for denying the full extent of Aboriginal title. So up until Delgamuukw, the provincial position was that Aboriginal title, if it ever existed, and probably didn't, was extinguished. And that was rejected in Delgamuukw. And after Delgamuukw, the position was that Aboriginal title, if it does exist, then only exists to these very tiny spots in the province. And that's been the basis of provincial policy. And the Supreme Court swept that aside with this decision and confirmed that First Nations, this is a quote from the decision, enjoy title to all the territory that their ancestors regularly and exclusively used when the Crown asserted sovereignty, which in BC is considered to be 1846. And so that's from the highest court in our land. And the way they've described it, that's a considerable amount of territory. And we haven't come, I would say, anywhere close as a province to reckoning with Aboriginal title on that scale, to that extent. So I just take a moment to underscore how significant it is, the Aboriginal title to all the territory that their ancestors regularly and exclusively used. I just want to just quickly go through what Aboriginal title means. Like I mentioned, it's a right of ownership It includes the rights, this is from the Supreme Court of Canada, to control the land and decide how that land is going to be used. That use can be for traditional purposes, but also for modern purposes as well. It's not confined to the traditional uses of the land. And it's the right to benefit from the lands and resources. So the economic fruits of the land, as the Supreme Court of Canada said, come with Aboriginal title. If I could just zoom in on one of those rights, to control the land and decide how it will be used. The court didn't go far beyond here in describing what that means, and probably it will be a matter of some debate over the next while, but my view is that embedded in that right to control the land and decide how it's used is space for Indigenous laws and legal traditions to be exercised. Indigenous systems of governance and political systems to emerge or to be recognized. If you're talking about controlling the land, deciding how it'll be used, then you're also talking about institutions and rules and laws for how you're going to make those decisions. And this case is a prime example where the Tsilhqot'in Nation, who's recognized as holding the title and the rights, doesn't exist under the Indian Act. It hasn't been recognized by BC, but it's been found now by the court to hold these rights and titles. So it's a validation of a traditional system that now has modern expression, and it creates the space for that Indigenous level of government to emerge. And it also creates the opportunity for land and resource management in that area according to the cultural values of the group and their own priorities and their own ambitions and goals. So, bottom line, I guess this remains to be determined, but it appears that Aboriginal title carves out this space for Indigenous laws, Indigenous systems of government, all the diverse forms that takes in BC and across Canada to emerge and flourish and adapt over time, just like any other government or system of law. So it's an incredibly exciting part of the decision to think about the space that's creating in our Constitution. The Supreme Court of Canada confirmed, this is the question of what happens when Aboriginal title bumps up against the province and up against the federal government. How do we work that out? The Supreme Court confirmed that the province in Canada where title has been found, like this case, must seek the consent of the nation to interfere with that title. And they went on to say, otherwise they can't interfere unless they meet a pretty demanding test to justify interfering with title. I won't go into the nuts and bolts of it, but there's a few things the court said that suggests that the times when the Crown will be able to justify interfering with title will be exceptional, will be rare, not least because they said that the Crown has to demonstrate that interference will actually further reconciliation. So that's an interesting take, and I'm not quite sure what that means, but surely it's a limit on the Crown's ability to interfere. And the court confirmed that the land use planning and forestry in this case unjustifiably infringed Tsilhqot'in Aboriginal title. There's an example right there. I believe Krista is going to speak more about the implications for consultation and accommodation, so I'm going to briefly skip along through this part. But the Supreme Court confirmed that before title is proven, the HIDA consultation accommodation framework continues to apply. You might be familiar with that, but HIDA basically says the stronger the evidence of title, the further the Crown has to go to consult, and the deeper they have to go to accommodate. And so rather than a consent regime before proof of title, the court's saying you're in a HIDA consultation regime. But again, they threw a couple more warning signs in there and said, if the title claim is strong and you're close to proof, then the burden is on the province to preserve those lands until it's finally resolved. And also caution that if the province proceeds to give authorizations before title is proven and then a nation goes to court and does prove their title, the province should be prepared that they may have to revoke those authorizations or cancel that project. So a couple of red flags going up from the Supreme Court of Canada. And I think it's interesting, the word consent gets mentioned numerous times in this decision. And one of the things the court says is industry and government, you can deal with this uncertainty by getting the consent of First Nations to develop. Whether it's required by law or not, it might be the easiest and most certain path forward for development. I think that's a signpost of the way ahead. So even where title isn't proven, I would argue that the court has said consultation has to be deeper, accommodation has to be far deeper, than the Crown to date has been far deeper than the Crown has been willing to recognize or accept. And I'll leave that for Krista and others to discuss. So, by way of concluding remarks, there's a lot that can be said about the implications of this decision. I wanted to conclude, I could go on for a while about the implications, but I just wanted to conclude with some comments about this incredible moment we find ourselves in after this decision, not just as a result of this decision, but as a result of 150 plus years in BC of struggle by First Nations for recognition through court cases and other means. And now with this decision, we're in a place where we know, the highest court in the land has confirmed that Aboriginal title does exist in British Columbia. And it exists over large territories, certainly larger than we've come to grapple with up to this point. And the court has said that along with that title comes the right for First Nations to have a pretty significant degree of control over those lands in the core of their territory, and to see the real benefits from those lands and resources. And they've had that right always, certainly at sovereignty, and today they have that right as well. And the challenge that we face is that the status quo exists in denial of the full extent, geographically and in terms of content, of Aboriginal title. We exist in a system now, even with the HIDA framework, where in the consultation accommodation framework, where First Nations still have for the most part, have very little say in what's happening in the core of their territories and the future of their lands and their culture. And they're not seeing the real benefit of what's going on. They're still condemned for the most part to poverty, while others are reaping the economic benefits of their traditional lands, and we know that they have the rights at first instance to those benefits. So, the questions becomes, I've had it described to me as strongly as the status quo is illegal. Certainly the status quo is unacceptable given what the court has said and the new world we find ourselves in. And we're faced with the challenge now, or the opportunity to look at it differently, of moving from this long history and these policies and these structures based on the denial of Aboriginal title. How do we move from there into a regime where there's one of recognition? First Nations are recognized as having the rights to participate as full partners in the future of their lands and in the future of the province, the economy of the province, according to their own laws, their own traditions, developing their own legal and political structures to actualize that through. So it seems to me we're at a point where the government has to make a decision and is making a decision, and we all have to make a decision about whether we're doubling down on this history of denial, which undoubtedly is going to lead to more conflict and more uncertainty and more block development, or whether we're going to explore new ways of working together that really recognize Aboriginal title and the rights of First Nations to exist as self-governing, independent bodies with the rights to control their territory and their future. So I'll get off my soapbox now, and I'll leave you with those thoughts. I'm looking forward to hearing very much what the other presenters have to say. So thank you very much for your patience.
I think I'll stand here. Is that all right? Okay. Well, good afternoon, everyone, and thanks, Jay, for your remarks, which I think really set the framework for my comments. I was asked to speak about the implications of the decision from a regulatory perspective. I have 9 points, and I'm going to walk through them. My approach to this presentation is going to be to try and paint a picture of what's really been happening in the last decade on the ground in terms of consultation and accommodation. So it gives us, I guess, a comparative basis to think about what the implications of the Tsilhqot'in decision are and how it might change things going forward. Okay. So, of course, the starting point is the Delgamuukw case, which was decided in 1997. So Aboriginal title has moved from a legal concept that was recognized in that case to an actual achievable reality, and that's very significant. I think it's important to start with the Haida Nation case. Jay gave a good kind of backgrounder of that. But to give you the time frame, it was 2002 when the BC Court of Appeal decided that, and then the findings were essentially upheld by the Supreme Court of Canada later, 2 years later, and held that in cases where Aboriginal rights, including title, had not yet been proven, the government still had a legal duty to consult and accommodate with the First Nation who had asserted those rights in a pre-proof stage before authorizing any activities that could affect those claims. So to give you a sense of kind of how that was playing out on the ground over a decade ago, I'll tell you a story about a consultation table that I was at. Shortly thereafter, it was replacement of forest licenses, and the district manager was trying to do consultation with the First Nation. And the approach is what the First Nation was unaffectionately referring to as the berry patch model of consultation. You know, tell us where your berry patches are, we'll log around them. And what the First Nation was saying is, no, we have Aboriginal title here. This is our land. We have ownership of the trees in this valley. And I remember so clearly the district manager saying, you know, give me something I can work with. You know, like as if it just wasn't on the table. The idea of title, it wasn't, notwithstanding that Delgamuukw was there, it just wasn't something that the province was prepared to start negotiating about in terms of accommodation. And I think that has changed now with the Tsilhqot'in decision. The reality that First Nations can and will prove title, I think will have impacts at every level of the consultation. So for example, a lot of consultation starts occurring in the environmental assessment process of major development projects. And we're always trying to push for that to be meaningful, for the terms of reference for those assessments to have to include assessing what will be the impact on Aboriginal rights and title. And it's really difficult to get traction, to get sort of really any kind of meaningful assessment of how is this project going to affect Aboriginal title. And again, I mean, we keep pushing on this, but there's this idea that it's this kind of amorphous and theoretical construct, but it is not anymore. And I think that we will be able to get a lot more traction in terms of the government addressing those rights at that level. So I think Jay's covered this really well. We have now a practical and realistic interpretation of what is required to demonstrate exclusive occupation. So we know now that it can be a territorial-based claim for what the court described as a semi-nomadic Aboriginal group. It's not just village sites and enclosed fields. And that would be extremely difficult to prove for most nations. And I think, but just to give a bit of context, I mean, not just the BC Court of Appeal decision in Tsilhqot'in, but prior to that, for instance, in 2005, the Supreme Court of Canada in the Bernard and Marshall cases, they said there was Aboriginal title that was asserted there, and although the court articulated the tests in terms of Delgamuukw, you know, and respecting the Aboriginal way of life as part of the perspective that you have to bring into the assessment of occupation. In those cases, the court found no, that occupation wasn't sufficient to establish title there. It was too intermittent. It wasn't intensive enough. So that was really the fear. I mean, can any nation actually prove title? So I think we now have a lot more clarity of what it takes to meet the test, and in my view, it's a much more fair interpretation of what that test is. I was also speak a little bit about water and how that would be affected by the Tsilhqot'in case. So the title to water was actually not determined in the Tsilhqot'in case, and it hasn't actually been determined in other cases. There's certainly been claims to submerged land. For example, the Haida Nation in their title claim, which hasn't yet been litigated, have claimed a fair bit of Hecate Strait, but it hasn't been decided. I think, though, it's with this territorial concept of title now, it really does lay the foundation to make claims to water courses and water sources. In terms of, there's also been a lot of examples in court decisions when the court's discussing the test to prove title around sort of regular use of fishing sites, watercourses, et cetera. So I think there's a very good foundation for that. One example that comes to mind is clam gardens on the West Coast, where First Nations have been intensively cultivating and managing clam gardens, which are, semi-submerged lands, at least intertidal lands. Similarly, I think where there's a territorial claim that's made out, where you have rivers that are used regularly for transport and things, I think there is kind of a strong potential just based on the language of the court about what occupation means to make out a claim for water, but that hasn't been firmly decided. So I want to talk about this point in quite a bit of detail in terms of that the Tsilhqot'in raises the bar for consultation both before and after a declaration of title. Just as a preliminary comment, I think it is certain now that more claims to Aboriginal title will be brought. The Tsilhqot'in case, I think, really blazed the trail in many respects. I mean, as Jay could attest, that there was dozens of motions that were occurring kind of before the trial and in the course of the trial around procedural matters that made it so long and so expensive, around issues like, who is the proper group to make the claim? How can oral history be heard? Should third parties be named? And so on. So I think although these things will probably be argued again in future claims, there is some clarity on those procedural aspects with respect to a title trial. So hopefully that will make litigating these things kind of more sort of reasonable cost-wise and simpler. So that, I think, in itself is a significant impact of the decision. But in terms of the short term, but really, it's still, make no mistake, to prove Aboriginal title is going to be an expensive and lengthy undertaking for any nation. So the short-term impact that I'm going to focus on is how is it going to change the consultation and accommodation framework before a declaration of title. So I think Jay's kind of laid out the Haida Nation case, so I'll kind of just, in a bit more detail, talk about how the courts have interpreted what the duty is to consult and accommodate over the last 12 years since that was decided. But I think boiled down, really, it's that pre-Tsilhqot'in Nation, before the Supreme Court decision, Canada decision, in a pre-rights context, it's really kind of a procedural obligation. The government has a duty to give the First Nation information about proposed decisions, hear the First Nations concerns about that, and as I said, kind of really boiled down, has to, where possible, integrate the First Nations concerns into the course of action it adopts. And depending on that exchange and the extent that rights could be impacted, the government has to accommodate in that fashion. So as Jay said, the standard now for consultation post-title is effectively consent, with some modifications and qualifications, but that's effectively the test now. So with respect to before a declaration of title and how consultation is affected, I think Jay said really, address those remarkable comments of the court around, that if a title claim is close, that the government has to preserve, can't take steps that wouldn't preserve that right. And this, I think, could also apply to treaty negotiations, not just litigation. That the court's saying that if title is proven, that the government may have to cancel projects that proceeded before that declaration was made. And similarly, if legislation was validly enacted, this is a direct quote from the case, before title was established, such legislation may be rendered inapplicable going forward to the extent it unjustifiably infringes Aboriginal title. So the concept of being able to revoke development permits is not new from this decision. It's been really the legal tool that's been driving the consultation process since Haida Nation in 2002. Certainly First Nations can use judicial review procedures to go to court and have permits reviewed, and permits can be quashed. And that's not insignificant. But I think the comments that the court have made in terms of if title can realistically be proven, and the new standard can be retroactively consent. I think that really does sort of change the dynamic of consultation and take it to a new level. So I'm going to just read a quote again, because I think the court said it quite clearly. At paragraph 97, the court said, "I add this. Governments and individuals proposing to exploit land, whether before or after a declaration of Aboriginal title, can avoid a charge of infringement or failure to adequately consult by obtaining the consent of the interested Aboriginal group." So point number 4, responses from government and industry are mixed. So I think we have to acknowledge, there's probably hundreds of ongoing consultations and negotiation tables that are occurring across the country between government and First Nations, between First Nations and industry. For example, in BC, in the LNG sector, the province has been kind of at an unprecedented level, I think, been trying to proactively secure the support of First Nations for that kind of development. I have certainly surveyed my colleagues on this, what's the effect of the decision at the tables that they're at. I think the party line is, nothing's changed. We've always known there's Delgamuuk, Haida Nation's there. Until there's a declaration of title, nothing's changed. Likewise, and that's not, legally that's not untrue, but when you look at the kinds of findings in the court, I think that things have changed. Industry lawyers are tending to say the same thing in their commentaries. The sky hasn't fallen. But we are seeing, certainly I am, at negotiation tables with industry where you're negotiating agreements around consent for projects. Typically, the First Nation is offered some kind of beneficial share of the project revenues, some employment, enhanced environmental protections, and in exchange, in the agreement, they demonstrate some level of consent for the project so that the proponent has some certainty that they can proceed with the project. What we're finding is the language that industry is seeking in those agreements is extreme in terms of sort of asking the nation to kind of forever irrevocably agree that their title isn't infringed by these projects. So I think we are kind of feeling that at those tables, that there is a feeling of uncertainty amongst industry. I think on a more positive note, in terms of treaty tables and other negotiations, I am hearing that, notwithstanding that the government is kind of taking the approach that nothing is significantly changed, at the same time we are finding that some new mandates are coming to treaty tables and to consultation tables. So I guess time will tell just how big an impact the decision will have. My comment here that First Nations need to be strategic about the extent of their title assertions to maximize leverage from the decision has to do with, again, that it's not insignificant to prove Aboriginal title. So Jay made the comment that title was declared for 40% of the claim area. It was actually a smaller proportion of the total traditional territory of the Tsilhqot'in Nation. Because the test is proof of exclusive occupation at 1846, even within the definite tracts of land on a regular basis, a more kind of generous interpretation that the Supreme Court of Canada gave, beyond the salt licks and the rocks, the postage stamp approach, is still a challenge. And the Tsilhqot'in and their traditional lifestyle and their isolation was a major strength in their claim. And as you know, it took years to litigate and a lot of money. So one thing I think that has to be kept in mind is the exclusivity part of the test. And although it's not absolute, that title can be shared, et cetera, it is, the exclusive occupation it's onerous to meet. So a First Nation that comes to a negotiating table claiming title to their entire traditional territory, particularly where there's shared uses with other Aboriginal groups, or otherwise competing or overlapping claims, do risk undermining their overall leverage in the pre-proof consultation framework. So I think that I think that First Nations will be mindful of that and will be strategic around where they choose to aggressively assert title in negotiations or choose to litigate that. But I think Jay's covered this very well, but a really important thing about the Tsilhqot'in case, I think that does get overshadowed with the declaration of title, is just how it established such important and far-reaching principles about non-title rights, which the higher courts didn't touch. So just to back up a little, so title is one species of a whole range of Aboriginal rights that are protected by Section 35 of the Constitution. So hunting, fishing, trapping are the typical rights that we think of as being the non-title rights. So it's really important not to overlook the potential and the significance of getting declarations around those rights. They don't have to be exclusive, and once they're proven, they significantly raise the consultation bar beyond the HIDA framework, not to a close to consent level. It's called the Sparrow framework, but the justification test for infringing those rights is a significant burden on the part of the Crown. So in the Tsilhqot'in case, as Jay said, the court declared that Tsilhqot'in had rights to hunt and trap the whole of the claim area. And found in that case that those rights were unjustifiably infringed by the logging that was proposed. And this kind of amazing language of Justice Vickers in the lower court that wasn't overturned by the higher courts around the province effectively having a burden to show that those rights can be sustained, in light of whatever the development proposal is. And in the Tsilhqot'in case, the court found that the province didn't have the data to show that the species that the Tsilhqot'in relied on could be sustained if logging occurred. So I think Tsilhqot'in is an incredible precedent, really, for the protection of Aboriginal rights, the non-title rights, and that you don't have to necessarily show improved title to protect a way of life. I'm just going to touch on this one because it is an interesting aspect of the decision. I think I've called it clarification. I have in my notes the settlement of the division of powers question. So I pulled back on that a little bit because I don't think anything's ever really settled in that regard. But we do have some. It is significant that we have some clarification around that long-standing question. So in the trial court, Justice Vickers actually found that the province could infringe Aboriginal rights but could not infringe Aboriginal title, did not have the constitutional power to do that. The Supreme Court of Canada actually did overturn that and found that the province could infringe Aboriginal title, but under the same framework of justification that Canada would have, because it is a right that's protected under Section 35 of the Constitution. There was another recent case of the Supreme Court of Canada called the Grassy Narrows case. That's also kind of a very important case along that line. So the two together, I think, are significant in terms of clarifying the law. In that case, the First Nation was arguing that Ontario didn't have the constitutional ability to infringe rights under Treaty 3, and the Supreme Court of Canada in that case found that Ontario could do that, but that the province would be held to that same standard of honor that Canada would be, kind of stepped into the shoes of Canada in terms of the treaty. And so while this was kind of occurring in reality, that the province was making decisions that were infringing Aboriginal title and treaty rights, it was an unsettled legal question, so we have a lot more clarity on that point now. Implications beyond British Columbia. So just briefly, I think in theoretically no, in that the Tsilhqot'in decision applies to lands that are not subject to either historic treaties or modern land claims agreements. But I think I did a presentation in Ontario on this topic, and when I thought about it, I think it's really an untenable situation that you have where you have Aboriginal title and no treaties, that the standard of the Crown to consult with and accommodate First Nations would be lower in areas that were covered by historic treaties. So I think that I hope that we will find that kind of the bar will generally be raised around what is the honor of the Crown in terms of making decisions that could infringe title rights in a pre-proof context and historic and treaty rights. I also think as well the political climate as it, kind of across the country does, there's an interplay between the provincial government policies. So for example, around revenue sharing, where some right now, some but not all provinces in Canada, where provincial governments are sharing revenue from development projects with First Nations. So that's an example. I think that's kind of been driven in part in BC from Tsilhqot'in, Haida Nation, and other cases, but that's starting to happen in other provinces as well. So I think that that we'll see this kind of raising of the bar in provinces where historic treaties are in place, and not just in territories in British Columbia where a First Nation has proven title. So I'll just close by talking a little bit about the likelihood of legislative amendments in the future. So there's some interesting findings in the Tsilhqot'in decision around the Forestry Act not actually applying to Aboriginal title lands because it's no longer Crown land that's as defined in the Forestry Act. So, I mean, really, the government's going to have to, if it wants to conduct forestry on Aboriginal title lands, amend the Forest Act. And as I noted before, the court's comments that if legislation was validly enacted before title was established, that such legislation may be rendered inapplicable going forward if it unjustifiably infringes Aboriginal title. So that suggests that governments will have to anticipate developing legislation that can kind of structurally accommodate Aboriginal title as we hopefully see more lands in the province being subject to those kind of declarations. The duty to consult with First Nations about legislative development isn't well established in law, but it certainly is occurring in practice. And I think in light of the decision that First Nations can expect more engagement with the province around the development of legislation. So in closing, I think that the Tsilhqot'in decision does represent a very significant advancement for Aboriginal rights, both title and other rights. And while we can expect that government may try to minimize the effect of the decision, I think that First Nations will certainly seize on the opportunities that it presents. And government industry will have to address Aboriginal title as a reality. So going back to my kind of first comments around consultations on forestry decisions in 2002, I think title now is undeniably on the table. So those are my remarks. Thanks.
I'd like to also acknowledge the territory on which we're gathered as Coast and Strait Salish territory. And I'm grateful for you being here today and your attendance. I'm grateful for those who have organized and sponsored this gathering. And I'm also grateful for the opportunity to be able to consider in a little bit more depth some of these issues. I want to begin by saying that I think that this decision is the best decision in the world dealing with Aboriginal title. I make that by judging it against teaching in this field in the United States, Australia, New Zealand, Norway, places in Southeast Asia. And I think it is unparalleled, and so there is quite a cause for celebration as a result of what has been developed and what you've heard about earlier. I think part of that is the holding that there is a declaration of Aboriginal title over Tsilhqot'in land in the area that was spoken about. Another part of that cause for celebration is that the Aboriginal title interest is a broad right to use land for a wide variety of purposes. In other words, it's a territorially based title and not just a postage stamp interest. Furthermore, the case was built on an incredible depth of information drawn from Indigenous peoples in their language about their own use and occupation and own legal traditions. And so while the Supreme Court has talked about the framework for recognizing Aboriginal title, if you want to see how it's done, you look at the trial and you see at the trial that Aboriginal law is at the heart of Canadian law. Aboriginal law has been accepted as a part of Canadian law because Aboriginal law is an independent legal interest in Canada that's now recognized by the common law here in the Tsilhqot'in case and is given the force of law constitutionally speaking. It's also a cause for celebration, again, because of the incidence of title that the court has recognized. The right to decide how the land will be used, the right to enjoyment and occupancy of the land, the right to possess the land, the right to the economic benefits of the land, and the right to proactively use and manage the land. These, accompanied with the significant limits that are found on the Crown if it wants to infringe that title, are again great cause for celebration. And I think it's worthy of placing the decision in this context. But I also want to raise some challenges with this decision. The decision isn't just an important victory for Indigenous peoples in Canada, but it can also be considered at another level a substantial loss. And I want to talk about elements of the decision that might illustrate that loss. Now, in writing the opinion, the Supreme Court of Canada made a really generous statement at paragraph 69. It said that the doctrine of terra nullius, that no one owned the land prior to the European assertion of sovereignty, the doctrine of terra nullius never applied in Canada. That is a significant statement. Terra nullius presumed that when the French or the English or the Spanish south of the border arrived in North America, the land was empty and therefore was open to be claimed by European nations to assert full title to those lands. And with that doctrine, of course, we know that the land wasn't empty. And so the justification for terra nullius was that the people that were living here were so low on the scale of social organization that they didn't have sufficient law to be able to claim title. And so when the Crown arrived and a foot was planted on a shore or a flag was put into soil, this doctrine of discovery was such that the entire underlying title for the Crown was vested in that interest. And here you have the court purportedly rejecting that idea. Again, to read, the doctrine of terra nullius, that no one owned the land prior to European assertion of sovereignty, never applied in Canada. But when you look at this more closely, the court, just right after saying that, reproduced and reaffirmed one of the most troubling aspects of terra nullius in the very same paragraph. And here's what the court wrote. At the time of assertion of European sovereignty, the Crown acquired a radical or underlying title to all the land in the province. This, for me, this reformulation is a restatement of the doctrine of terra nullius, despite protests to the contrary in the decision. That is, there's a presupposition that the landing on the shore, the planting of the flag, the putting of the foot down, gives another nation all the underlying rights, the radical benefits of being able to ultimately make decisions regarding use of that land and governance of that land. And so, despite the court's attempt to reject terra nullius, the court gives the Crown governance and use rights over Aboriginal land rights by virtue of the Crown's assertion of sovereignty. This, I think, still implies a discriminatory denigration of Aboriginal peoples' status in the world as nations, as peoples that were capable of possessing the full package of rights, the full bundle of rights that would be associated with property, land interests. And how does this occur? How does this get justified in Canadian law? By the mere assertion of sovereignty. By merely declaring sovereignty in 1846, the Crown is able to claim these rights. That assertion is the magic of Canadian law, which transforms Aboriginal people's historic relationships with land to standing on a bedrock of Crown interest. And there are implications that flow from that that are more than just theoretical concerns and are more than just a criticism of the discrimination and racism that's found in Aboriginal title. I want to play through 3 of these potential implications. The first one has to do with the proof of Aboriginal title. That is, Aboriginal peoples have to go to great expense and meet a legal test of sufficiency of occupation, continuity of occupation, and exclusivity of occupation in order to be able to establish title in the present day. That's costly, and that's not a test that the Crown has to go through, right? We assume that the Crown has that interest. There's no assumption of either the burden of Aboriginal title existing or the assumption that Aboriginal peoples themselves would have the underlying interest in that title. And with that proof, right, we create then an unequal playing ground, because then Aboriginal peoples have to go into the courts of Canadian law to be able to be held to strict and precise evidence on those 3 points of sufficiency, continuity, and exclusivity of occupation. This unequal playing ground has put Aboriginal peoples to great expense. It's estimated that the Delgamuukw case cost $25 million to be able to litigate when you count all the lawyers and court and public time that was put into that. It's estimated that the Tsilhqot'in case cost about $40 million to be able to bring to this conclusion. And those cases, particularly the Tsilhqot'in case, was partially funded through a public interest litigation strategy because of the great public importance of the issue that was being raised. The next case that's dealt with in Aboriginal title terms will not fall into such a category, and thus public funding will not be available to be able to bankroll the litigation. So this cost of litigation will place the court-ordered recognition of rights beyond the reach of most groups. Now, we might think, well, there's another way to achieve recognition aside from going to court. We could negotiate about it. We could create a treaty in recognizing and affirming those rights. But we also know that there's been a 20-year process of treaty negotiation in British Columbia, which has been a dismal failure, by and large, for most groups, as they've accumulated millions of dollars of debt in trying to negotiate, given narrow mandates that are often in place. And it's unlikely that, at least in the short term, that there's going to be much of a prospect of being able to bring recognition to fruition through the treaty process as well. So this idea that the Crown has underlying title has real significance for the cost that Aboriginal peoples are placed that have to bear as a result. Now let me just provide an example from a case that came down yesterday. As you know, we are gathered on Douglas Treaty lands here, and the Songhees and the Esquimalt are alleging that under the Douglas Treaty, the promise to set aside villages and enclosed fields, that's what Governor Douglas promised the Songhees and Esquimalt people, that these village sites and fields would be set aside. These nations are alleging that these promises were never fulfilled. And so they're in litigation with against the Government of Canada and the Government of British Columbia to hold the Crown to its promise under the treaties. Well, as a part of the management of this case, the Justice Perlman put the parties into a couple of weeks of dispute resolution, hoping that they might be able to negotiate rather than litigate, and that failed. And part of the failure was that Canada was willing to negotiate, but British Columbia was not willing to admit liability as a part of their involvement in this potential infraction of the treaty. And so what happened is the Songhees and Esquimalt First Nation brought an action saying that there was a legal duty to negotiate in good faith in resolving rights under Section 35(1) of the Constitution. In fact, paragraph 18 of the Tsilhqot'in decision says, and I quote, "Governments are under a legal duty to negotiate in good faith to resolve claims to Aboriginal land." Now here's Justice Bracken's response. He says, he ruled that the Tsilhqot'in decision does not stand for the principle that there is a duty to negotiate a disputed claim. And now let me just quote in greater detail his reasons. It's only a 19-paragraph decision. He says, first of all, Canada submits that there is no duty to negotiate the resolution of this action, and says the Tsilhqot'in does not change the law. It, that is Canada, argues that the honor of the Crown principle does not compel the defendants to negotiate a claim where liability is disputed. Canada points out that the duty to negotiate was not at issue in Tsilhqot'in, and the comments at paragraph 18, the ones I read to you earlier, are only appropriate in the context of that case, and it did not establish a new principle of general application in Aboriginal rights cases. Next paragraph. British Columbia takes the same position as Canada and says that the defendants are entitled to stand on a denial of liability, and the Tsilhqot'in does not require either Canada or British Columbia to enter into negotiations or to tender an offer of settlement. And so then here's Justice Bracken's response. Clearly, there will be significant costs associated with this litigation. My words, $25 million from Delgamuukw, $40 million in Tsilhqot'in. I go on now. Chief Robert Sam's affidavit says the costs of a trial will bring a significant economic burden for the Songhees nations. I do not dispute that. Last paragraph. Nevertheless, I agree with the submissions of the defendants. Tsilhqot'in must be read in the context of what was at issue in that litigation. In my view, the court did not create a new principle of general application requiring negotiation in all Aboriginal rights litigation. Rather, it commented that the honor of the Crown required the Crown to consult and accommodate those claims in a manner proportionate to the strength of the case supporting the existence of the right or the title claimed. Now, let me just say that there was no reference to the Crown's duty, which was found in the Sparrow case and Delgamuukw and Tsilhqot'in, for the Crown's duty to act in a trust-like manner when dealing with Aboriginal cases. It did not cite the well-known canons of construction surrounding Section 35(1), which is to give Aboriginal rights a large, liberal, and generous interpretation, resolving any ambiguities in favor of the Indians. The court instead relied upon arguments for proportionality. And given the power imbalance in Canadian society as Aboriginal peoples relate to the Crown, arguments of proportionality often favor the status quo and not the emergent recognition of Aboriginal rights as we see here. So there are problems with terra nullius that are demonstrated in the proof of Aboriginal title and the unwillingness to be able to read the broader spirit of the opinion into particular cases, whether it be at some tables or whether it be in a litigation context, given the position that both Canada and British Columbia adopted in this case. There's also a third issue which has to do with the infringement of Aboriginal title, which again flows from the underlying nature of the Crown title. It's quite clear that Aboriginal title can be infringed or diminished as a result of the Crown's superior position. It gives the Crown paramount status to encroach on Aboriginal title, not the other way around. That is, Aboriginal peoples have no right to unilaterally diminish constitutionally vested interests that the Crown might claim. The Crown can diminish Aboriginal title in the public interest if it has a compelling and substantial legislative objective and acts honorably through ensuring that the incursion is necessary to achieve the government objective, that the government goes no further than necessary to achieve its goals, and that the benefits from the goals are not outweighed by the adverse effects on Aboriginal peoples. This balancing test in infringement, again, is a one-way street, by and large, that flows from the paramount estate that the Crown continues to be able to exercise. In this area of law, I believe we should not necessarily always be searching for proportionality, for measuring the harms to Aboriginal peoples against the benefits to non-Aboriginal interests. In this area of the law, sometimes it would be helpful not to just search for a synthesis of these differing views. That is because reconciliation can itself be a flawed metaphor in the field of Aboriginal rights if it requires Aboriginal peoples to be conciliatory to the very institutions and activities that have ravaged their societies through colonial action, legislation, and inaction or passivity through the years. That is, proportionality, reconciliation, any compromise with colonialism causes us to be compromised by colonialism. It's not always enough just to saw off the differences between problematic and laudatory versions of Canada's constitutional narratives. When we think about what the fulcrum is here, the fulcrum is in place because, despite the court's protestations to the contrary, terra nullius, in effect, still continues to operate in Canada. Final point I want to make, which has to do with the balance of power issues that were discussed earlier. As you heard, the Supreme Court allowed provincial laws of general application to govern Tsilhqot'in lands. Now, in 1951, in the Indian Act, there was federal legislative authority that was given to the provinces to make laws of general application that would apply to Indian lands. That's something that occurred through parliamentary activity acting under their constitutional responsibility pursuant to Section 91(24) of the Constitution. In other words, it took an act of Parliament to have provincial laws apply to Indians. Now, the court's bald declaration is that provincial laws of general application apply to govern Tsilhqot'in lands, and the reason for arriving at this conclusion is that, quote, a legal vacuum would exist in Canadian law if provincial laws did not apply to Aboriginal lands. Let me take that apart in two ways. First of all, that assumption of a legal vacuum does not recognize the very evidence on which this case was proven, that these people have laws that are capable of organizing themselves and are very attentive to the sustainability and the ecological health and economic health of the nation in the area. So to say that a legal vacuum exists in Canada if Aboriginal title was to be there and therefore you need provincial laws to apply is to undercut an earlier conclusion that the court itself relies upon. Secondly, this finding goes against 250 years of constitutional principle. In 1763, in the Royal Proclamation, the law was that lands are reserved to Indians, and that if the Indians are going to do anything to share those lands with others, it has to be in a public meeting called for that purpose, and it has to be done by the Crown in right of England, calling that meeting and transacting that business. In other words, the local colonies were forbidden to enter into relations with First Nations. The reason for that was, and they say it in the proclamation, great frauds and abuses would be committed by those that are most proximate to First Nations people. In other words, who has the greatest incentive to develop Aboriginal lands? It's those that are adjacent to Aboriginal lands. They see the opportunity for mining, for forestry, or back in the day for agriculture, setting up milling sites. And so the constitutional principle is that there was a check and balance in Aboriginal rights law. The check was the more distant power would regulate the land to prevent the more local power from exercising those perverse incentives that might cause the molestation or disturbance of the Aboriginal interest. 250 years ago, this very summer, something called the Treaty of Niagara was negotiated in central Canada, where there were 24 different First Nations represented at Niagara, 2,000 people. They heard the terms of the Royal Proclamation read to them. They then had wampum belts, beads of shells sewn onto hide, that was in accordance with their protocol, that talked about what the relationship would be between the Crown and the First Nations. And those wampum belts, the speeches that went on for 2 months, that you interpret the Royal Proclamation by, were very much of the point that this was to be a nation-to-nation relationship, not a nation-to-colony relationship, or not a nation-to-province relationship. And so what's occurred in this amazing decision, which is a cause for great celebration, is also the overturning of one of the planks, the bedrocks of Aboriginal people's constitutional Magna Carta, as the court has called the Royal Proclamation in times past. And in overturning that Magna Carta, this is how it was expressed in the courts in the United States. The people of the states are often the tribe's greatest enemies. Now, it's not the case that people it's not the case that people would maybe interpersonally be hostile to one another. You can have great relationships between local Indigenous peoples and local municipalities, farms, cities, and there's a lot of intermarriage and there's a lot of things that can be done. But that's not the point this was directed at. It wasn't the nicety of the relationship so much as it was trying to check some of those problematic incentives. And so, given this acceptance of terra nullius, despite proof to the despite words to the contrary, we have issues with the proof of Aboriginal title, which place Indigenous peoples to great expense and causes them to have to bear a burden that the Crown could never meet. In many places in British Columbia, the Crown would still have difficulty showing that it had sufficiency of occupation, continuity of occupation, and exclusivity of occupation. There's also a problem, as I've mentioned, with proportionality in relationship to infringement, and then there is the challenge of describing areas that are subject to Aboriginal title as being part of a legal vacuum. And so I think it's important to put both of these questions together to recognize the great work that still stands in front of us if we are going to get over the discriminatory characterization of Aboriginal peoples as having lesser rights when they interact with the Crown. This is a great step on the path to justice, a tremendous step on the path to justice. It is a step. We are not at that destination yet. And gatherings like this, work that's been described this afternoon, is a part of the further responsibility that that lies on all of us as British Columbians to make sure that we create a society that is in line with our higher aspirations that are recorded in this opinion. And with that, I'll say thank you.
Well, thank you, all three of you, for very different and very interesting perspectives. I'm not going to say enlightening, because that has a very value judgment laden with it. But it is, at least, it's interesting for me as a lawyer to hear three very different takes on what one could see as a simple or a complex legal judgment where in theory, the law speaks with one voice, which of course we know it doesn't. So I'd like to open it up for questions now, please. I also wanted to mention that we did invite the provincial government to send somebody to come and speak with us today about, or to join the panel. And our request was declined at this point in time. So Margaret has the microphone, so I see a question up at the back there, and we will also be taking questions from the folks who are listening online. And what I'll do is I'll just ask you to please state a question in less than 30 seconds, and then we will turn it over to whoever wants to answer it.
Okay, I'll try and keep it less than 30 seconds, but I wanted to bring up the question of foreign investment agreements and how this is going to play into this kind of decision. As we know, last week the government signed the FIPA agreement with China, giving them incredible powers over land, particularly in BC, unceded lands, and factoring in the Tsilhqot'in decision. That tribunal is going to be secret with only 3 people for appeal, and so I am wondering, my question, hope I'm not taking too long, my question would be, how would you project this decision and future decisions around title, factoring into foreign investment agreements that are giving over tremendous power to countries like China?
Wow, does anyone want to bite that one? John?
Okay.
You're up.
Well, there is some precedent for thinking through issues of foreign investment with the NAFTA agreement, and we know that there are First Nations in the interior that have been very active in trying to show the negative impacts that they feel they're under as a result of the way NAFTA has been interpreted. I think part of the question is going to be whether or not a declaration of Aboriginal title amounts to an expropriation of a foreign interest that then requires compensation under these trade agreements. And that's a matter of characterization. Maybe the prosperity mind might think by the creation of a park that the Tsilhqot'in people have made in their territories, an expropriation of their interest for mining in that place, and I know that there would be good arguments on that front, but let me just suggest that even the law of expropriation, even international law, should be colored by the framework of this decision, which says when you talk about law dealing with Aboriginal title or Aboriginal property, yes, the common law is there and helpful by way of analogy, but it's not determinative. You also need to consider the Aboriginal perspective on the meaning of the right at stake. And Aboriginal peoples would not consider this expropriation because they would say this is ours all along, and there's just a mere recognition now of something that should have been long ago a part of the property rights in Canada.
Okay, great.
One part of this judgment that really tripped me up is where the Supreme Court gets into this justification test, where if you can't get a First Nation to consent to a government project, they can still justify going ahead with that project so long as it has as its objective reconciliation. But then, well, first of all, we're talking about a project that the First Nation has not consented to. And then as examples in the very next paragraph, paragraph 83, they talk about forestry projects, mining projects, agriculture, et cetera. And they seem to be talking about projects of that nature that have been approved over the objections of First Nations. And so my question is, do any of you have any thoughts on what exactly the Supreme Court means by aimed at reconciliation if we're talking about projects that the First Nations didn't want to happen in the first place?
I'll give that a shot. Well, I have to admit that tripped me up as well and continues to trip me up. I think it's important to recognize this is all uncharted territory in some ways. And unlike other areas of the common law where we've had hundreds of years in some cases of development of the fine details of the law, the Supreme Court of Canada we're in kind of the here be monsters part of the map, right? It's completely uncharted. I think what they're trying to do is something very difficult, balance the recognition of the right of the First Nation to control the land with the fears that it means complete abdication of control by the province. That's going to be, frankly, a very real consideration for them. For me, it harkens back to the Chief Justice in the Gladstone trilogy. It was some fishing cases in the mid-1990s that Vanderpeet, Gladstone, NTC Smokehouse, that defined Aboriginal rights. And she was in dissent in those decisions on the issue of the justification test. And she was worried, and the concern she expressed was that the test for justification and infringement that the majority was setting out amounts to, and I think John said this very well, it's a continuation of the history that's happened where the public interest trumps First Nations all the time. And she said it can't just be anything goes, the public interest always trumps First Nations interests. And so I think what we're seeing in that first glimpse into the future of where the court is going with this is her concern about it just being anything goes and any forestry project or mine that's going to benefit the broader community is justified. And I think there's a number of signals in her decision that in fact the bar is going to be much higher and it will be in exceptional cases. that a project would be approved over the objection of the First Nation. So, but those are wars that remain to be fought. Hopefully will never have to be fought, but may well have to be. But that's just my speculation on the road that the Supreme Court's carving out there.
If I could just also put 2 cents in, there's obviously a tension in the judgment between consent and the ability that the Crown has to override that consent if they can justify it. To add a moment of real politic to this, you might know 2 weeks ago in the United Nations Forum dealing with Indigenous peoples, there was a motion put forward once again to recognize the United Nations Declaration of the Rights of Indigenous Peoples, and there was every country in the world that accepted that reaffirmed motion, except for a reservation that Canada had, the one country to speak out against this motion, which was to say we don't agree that the Declaration gives the right of Aboriginal peoples to be able to have veto over development decisions. Consent, in many ways, is the discussion of veto, and maybe the boat's already sailed on Canada in that regard, and that the law of Canada is that First Nations have a veto, maybe. But if you read that other side of paragraph 83, like you talk about, maybe they're right. And maybe in Canadian law, at least, we have the paramount Crown interest, which enables the consent of Aboriginal peoples to be overridden.
But I don't know if I'm allowed to revisit my answer in light of what's been said. But I just wanted to add this, that it doesn't come across, a lot of what happens in law doesn't come across in the judgment itself. And so one of the things that doesn't come across is that a number of parties intervened at the Supreme Court of Canada, including Amnesty International and others, to argue that the Supreme Court should adopt the UN Declaration of the Rights of Indigenous Peoples and the standard of consent and the requirement of consent to major development on traditional territories. And although it's never cited in the decision, I think it haunts the decision in some ways. I think the court was very conscious of not wanting to carve a path that takes it increasingly away from the emerging international, or I would say the crystallized international perspective. And so I think you see that tension in the judgment, that consent is mentioned a number of times. It's encouraged. The bar is not quite set at where it is under the international human rights of Indigenous people, but it's carved out that way. So I think, like John has said, there's an incredible amount of work that has to be done, but there's also this momentum that when the case started, some 10, 12 years ago, there was no discussion of consent. I think even in our argument, the UN Declaration, of course, wasn't being discussed, and there's been this shift in consciousness that's happened even in that short period of time, where now there's this emerging recognition and consensus that that's what the debate is about. It's about consent. And so a lot of the old justifications for not seeing that right in First Nations are falling away. So it'll be interesting to see where we are, 10 years from now when we revisit this test of justification that you're talking about.
Regard to the, no, is it on? Oh, in regard to that, I wanted to ask you about the notion of peremptory norms. In Article 53 of the Vienna Convention on the Law of Treaties, a treaty is null and void if it violates peremptory norms. And a peremptory norm, in this case, in the UN Declaration of the Rights of Indigenous Peoples, would apply because usually a peremptory norm is something that has been in a treaty, a convention, or a declaration where either all states have agreed to it or the majority of states have agreed to it, and that it represents all ranges of legal systems as well as all geographical regions. And I was wondering wouldn't that apply in this case, because a treaty could be international treaty. I was thinking back to the question about the free trade. The free trade agreements would be deemed to be null and void if they violate international peremptory norms, and that this clause, Article 19 of the UN Declaration of the Rights of Indigenous People, I would say has become a peremptory norm that has to be recognized. I wanted you to comment on that.
So perhaps this is why Canada, at every meeting, says that we do not agree with this interpretation, because one of their constructions of international law is, in order to have custom crystallize, is there has to be this assent and this practice that is generally accepted, and by continuing to make declarations and act otherwise, they might be able to say that that peremptory norm is not in place here. Of course, there are other sides of that argument. Jim Anaya, who's the recent special rapporteur for the rights of Indigenous peoples, has written whole books and reports, even in his country visit to Canada, making the point that we have international law on this issue, which would suggest certainly a consultation and accommodation, but also consent.
Okay, I think we have a webcast question.
Okay, great. And then there's one behind you as well.
This question is from a remote viewer, Meryl Ann Fair. She states, in the lower court decision, the judge refers to title over lands and waters, but in the SCC decision, the language used is about title to lands without reference to waters. So in your view, does the Tsilhqot'in title include title to waters? And if so, what is the applicability of the BC Water Sustainability Act on tidal lands?
Wow, that sure played into my hand. Thanks, Marilyn. If you didn't hear the question, it was in the BC Supreme Court decision, the language the judge uses is title to land and water, but the Supreme Court of Canada talks about title to land. So what are the views, and then also what are the implications for our new Water Sustainability Act here in British Columbia, which all of us environmentalists like very much, but it obviously has implications for title.
Forgot about the webcast people. That was a good question. They have good questions. So at trial, and in the claim generally, the claim was to included also submerged lands, but also private lands. So it was the entire claim area, so the lakes and rivers and watercourses. And it's a bit of a complicated legal finding, but what the trial judge found was that because there wasn't an immediate conflict involving private lands or submerged lands, water, it was a forestry case, and the immediate conflict was on Crown land, land, not water. He found that there wasn't a sufficient conflict at law to support a declaration. So maybe another way of putting that is he felt that it wasn't an immediate enough conflict that the court should wade into it. And so he said he was going to exclude waters and private lands from his decision. And he avoided some complications that way, I think. When the case went to the Court of Appeal and then again to the Supreme Court of Canada, the Tsilhqot'in made the decision not to pursue title to submerged lands or to private lands in the declaration. And part of that is the overall approach of the Tsilhqot'in, which is to try and find ways to make things work. Even after this title decision has come down, you'll see that in how they're conducting themselves. And the idea was, it's a hugely contentious issue, both private lands and submerged lands. And the idea was to put the issue of title, which had not been recognized yet by the courts, already a difficult enough issue for the courts, to put that issue first in front of the courts and have them resolve that without these additional complications and emotions that arise around private lands especially. So the bottom line is the title lands don't, the declaration doesn't extend to the water courses, although presumably there's a very strong claim to title to those lands. So it's not directly decided by the Tsilhqot'in case, but the findings are there to apply in the future to claims to water.
And implications for the new Water Sustainability Act that is not yet in force, so it has been, will be brought into force by regulation looking at April next year with the groundwater licensing. So we don't have groundwater licensing in BC yet, but with a view to actually giving out entitlements to groundwater at that time.
This is likely a question for Krista, but in terms of a land title system perspective, and BC's land title system is well respected and often emulated. How do you foresee this case having any impact on the indefeasibility of title through Section 23 of the Land Title Act?
I think in terms of legislative amendments and what the court talked about, I mean, the new Water Sustainability Act, the Title Acts. I mean, these legislations may have to be amended to kind of grapple with the new reality of Aboriginal title lands. I'm not sure if that addresses your question.
No, it does.
Thank you. I had the great honor to work for many years with the Council for Yukon Indians negotiating team, part of the settlement of the land claim for the entire Yukon Territory in the late 80s, and I worked with the Tsilhqot'in Nation for many years and the Kootenays on treaty negotiations. I've sat in the room with many, many lawyers. I can honestly say the Department of Justice lawyers I've sat with are the most narrow-minded people I've ever met in my life. So given the fact that this, I agree, the Tsilhqot'in court case is the most clear declaration, unequivocal, of Aboriginal title in the history of this country, what could move those Department of Justice lawyers away from a position of complete denial to one of considering reconciliation?
Retirement.
So let me come to the defense of justice lawyers for a moment here. I had 10 years ago the opportunity to interview over 100 Aboriginal employees of the Department of Justice as a part of an Aboriginal audit. These were lawyers at many different levels of the organization. And in those interviews, I found many people of goodwill and breadth of understanding, and with a great desire to be able to make the world a better place. What I think that you often encounter at that level, though, are mandates that are set by the minister or the way they read the law themselves that constrains them from moving in that direction. So what do you do in that context? Well, one, you need the policy from the center to be more large and liberal and generous and not take these positions that I described in the case that I mentioned was issued yesterday. And furthermore, it is the duty of lawyers to be able to give advice to their client in the way that they best see the law. We are not for one moment living in apartheid South Africa. But when lawyers under that system felt they were abiding by the rule of law, they would often craft their opinions in ways that continue to support that status quo. Again, I want to emphasize we're not in a situation of apartheid South Africa, but for lawyers, it sometimes means making that harder decision in giving advice to your client, whether it be the Department of Indian Affairs or the Ministry of Forests, that you do not see the law the way that the mandate has been given from those that are in a position of authority over you. And so I think there are things that can be done on both of those fronts because there are many amazing people that work at all levels of government that I'm sure would be happy to have mandates that would enable them to act differently.
I agree with what John has said. I would echo that, and I would also say, maybe what's going to change those mandates isn't the direction from lawyers. It's going to be larger societal change, and in a way, it might be industry as well that's part of that change. It seems counterintuitive, but they're often ahead of government in terms of recognizing where things are headed. And we're in BC. We're in an interesting position where the Northern Gateway proposal was, theoretically approved, got regulatory approval, but I think people don't see it going forward, in large part because of First Nations opposition. LNG is in a similar boat, trying to have to figure out where that balance lies. The new prosperity and prosperity mines we worked on or projects where people have invested millions of dollars only to find that they're not going anywhere because of the unacceptable impacts they have on First Nations. First Nations haven't been involved in the decisions, they haven't seen their concerns addressed, and then they find themselves in the position of having to do everything they can to stop these projects from going forward. So, you know, if there is going to be this continued, very conservative, narrow-minded approach, whether from the lawyers or I think from higher up, then that's the path I see is one of just increased conflict and uncertainty, as I alluded to in my presentation. And you know, smart business already understands and sees, and I think smart people in government already understand and see that working with First Nations is actually the better route than working against them in a lot of cases. And there's, you know, it's kind of, you can do this the hard way or the harder way. I'm not saying it's easy to find that agreement with First Nations, but I think people are waking up to the recognition that getting that, bringing First Nations on board, respecting their cultures, recognizing their concerns and addressing them early on, getting their consent, that might be the way to do business in the province and to manage the province. So hopefully that's the direction we're deciding to head in.
Hi, I had a question, I guess, where John's presentation ended, or just like I guess all of you ended with thoughts about the future. But my concern or question is the limitations of a juridical approach, or like addressing these questions through the law. Because if it just reproduces the terra nullius kind of equation, and one can argue by looking to the Canadian legal system or to the Canadian court as an arbiter or source of authority on who meets the burden of proof or who does not, just in that very act, it reproduces that logic in itself. So does that suggest then this is a step, a fraught step, and perhaps it's necessary to challenge that authority in and of itself, such as maybe you see in the Six Nations land reclamation movements, or those more direct actions? Is there, like, how far can a politics of recognition or reconciliation be pushed and achieved through the legal system, through the courts? Because it seems to only reproduce that relationship at some level.
So, I think that we need to diversify our portfolio, which is we can't put all our eggs in one basket. That is, sometimes we pursue a certain path and it bears great fruit, but then it goes into recession. And in order to be healthy and vibrant, we have to have other approaches that are vibrant, alive, where we can also put our efforts if this other one is not being fruitful for us. And so I don't necessarily think it's an either or zero-sum game to think about pursuing the path of litigation or direct action or education or doing things completely outside the law, justice initiatives, education, social work. I think they all need to be a part of this process. But the point I do take from you is there are real limitations in the law, in working towards this, and the law can never be only instrument, step, institution, and sometimes, most often, it would be better served if it took the back seat. But if you'll recall, after the Constitution Act 1982 was enacted, there were a series of First Ministers' conferences to be able to negotiate what Section 35(1) meant. And we had the Charlottetown Accord, which was also an attempt to put content to Section 35(1), and the political process failed. And we're really in kind of a second, third, or fourth best world. We're not in the ideal world when we have to take this to court, given what we lost by not being able to have that more national conversation, which is Section 37 of the Constitution Act 1982.
Just make a couple points. One is I know many First Nations that don't want anything to do with the court system and are kind of asserting sovereignty on their lands, and that's that. And I understand that, and that makes sense. In terms of negotiation, and this goes a little bit to the question around the Department of Justice, I think a big barrier is this idea of precedent. So like in the BC treaty process, you've got the Tsawwassen Treaty, and so now that that's set, it's kind of like a program. You're going to sign on to kind of that, a similar, so it's this idea that this sort of fear of kind of being flexible in negotiations because of setting a precedent. But I just want to say also there is a lot going on in the private sector. A lot of the work I do increasingly is with companies and First Nations negotiating some really interesting agreements. So I agree with the comments before that reconciliation is happening, kind of beyond treaty tables and courthouses.
I'd like to thank you for a marvelously clear and cogent presentation. It's been very informative, even if Deb doesn't want to call it enlightening. I have a question. There's been reference to the language in paragraph 92, and it sort of picks up on the last comments about impact benefit agreements. I'm wondering if anything can be said about the challenge, particularly as private companies negotiate impact benefit agreements, as to who actually has the authority to give consent. There's an interesting question which maybe you'd comment on simply in the language of the decision vesting title in the Tsilhqot'in Nation. But a lot of the groups negotiating impact benefit agreements have a kind of cloudy status in terms of the authority to sign an agreement binding on a whole. Comment?
Well, I think you put your finger on a huge challenge for everybody, wherever they stand. And I would just preface this by saying it's in no small part due to a long history of not recognizing Aboriginal forms of government and politics. And under the Indian Act, you had a splintering of some nations into individual bands like the Tsilhqot'in, who are fortunate to have retained a functioning system as a nation. But yeah, and you also had bands that had nations that had no relation at a political level, that were put together, smushed together as one band. And then, you have a long history of messing around with the political structures of First Nations. And they're in the process, I think, now of unraveling all of that damage. And then you have to also appreciate that, like any other kind of political system, it shifts and adapts over time. I think there's this frozen in time kind of perception of Aboriginal nations, and there's this lack of agency that's attributed to their institutions to be able to develop and adapt to new goals and new ambitions, new challenges, just like any other government. So, I mean, they're right at the front lines of all of that, right? And working out how they're best going to respect their culture and their traditions and governance and function in this present environment. So I don't think there's an easy answer to how you identify who has authority. I think it's going to be different for every group depending on their history and their politics and their governance and where their communities want to go today. But I think the inquiry is one that's worthwhile and that the province should be undertaking, and business and of course the First Nations themselves are engaged in that work right now.
If I can also say, this is one of the preoccupations of UVic Law, because the answer to that question is answered by Indigenous Law. And the Indigenous Law Research Project here and Indigenous Law Clinic that Val Napoleon has run works with different communities to be able to draw out answer to those questions around who has that authority to be able to give consent. And we hope that one day there'll be an Indigenous law degree here that will further facilitate the inquiry and application of those issues. The second point is the good one too, though, that this is always a part of political life. Even if Indigenous law were to apply, there'd be disputes within Indigenous law as to who has that authority. And that's Canadian history as well. The St. Catharines Milling and Lumber Company of the 1800s in the Canadian constitutional history was about who has the consent to be able to give the permission to the timber company to be able to take the forests. this very case we're studying is still about who has the consent. Is it the province, is the federal government? So even on the federal side, we are still in somewhat of a cloudy vision in terms of answering that question.
Krista, do you have a final statement?
I would leave John Burroughs the last word.
Well, we have run out of time, but wow, what a privilege to have your three great minds to give us some insights in where we might be going, where we might not be going. But the fantastic thing is that the legal ground and certainly other ground has shifted in British Columbia, and it's really exciting then to engage and as it was put in this inquiry about how we move forward as a province. So please join me in thanking our panelists.